Yes, thank you very much. It's an honor for me to be here. And I'm originally from Naples, but I live from many years in Rome. So I try to balance between Naples, the south of Italy, and the north of Italy, Milan. So I try to very briefly to outline the regional form of state in Italy. The 1948 Italian Constitution, partly inspired by the Second Spanish Republic in 1931, outlined the regional form of state. Until then, Italy has been a centralized unitary state based on the French Napoleonic model. The idea of creating a decentralized state, which emerged at the time of the unification of Italy, did not succeed. The regional state, a completely innovative institutional arrangement at the time, was intended to take account of the geographical and economic differences between the various parts of the country and to respond to specific requests for autonomy from the islands and the border regions, such as Sicily, Valle d'Aosta, etc. The constitutional model was based on a differentiated compulsory regionalism covering the whole territory. The 20 regions are directly identified in the Constitution. The Constitution provides for two types of regions: those with special statute, Sicily, Sardinia, and so on, and those with ordinary statutes, the remaining 15 regions. Also named ordinary regions. The Constitution directly regulates only the powers of the letter. Specific constitutional laws define the autonomy of special regions, in particular with regard to legislative function and financial autonomy. For the ordinary regions, the conditions of autonomy are defined in Title 5 of the Part 2 of the Italian Constitution. The regulation originally contained the rights somewhat limited when compared to the principal proclamation of Article 5 of the Italian Constitution, which defines autonomy and decentralization as fundamental and immutable principles that characterize the Italian form of state. Now, some very briefly information about the evolution of the Italian regionalism. The regional state encountered considerable difficulties, so much so that its implementation was not completed until the 1970s. Thus, in 1999 and 2001, in the most far-reaching constitutional reform in Italian history, the entire Title V of the second part of the Constitution was amended, further strengthening the autonomy of the regional authorities to such an extent that the word federalism began to appear in political debate and in the mass media to define the Italian form of the state. Constitutional Law Number 1, 1991 granted the regions full organizational autonomy, including in terms of their form of government, by abolishing parliamentary approval of regional statutes. Constitutional Law Number 3, 2001 reversed the criteria for the allocation of legislative powers, introducing a list of matters of exclusive competence of the central state and delegating the remaining powers to the regions. The list of state matters is very broad, including criminal law, civil law, environmental protection, protection of the free market, and the guarantee of basic civil and social rights. On the other hand, the residual powers of the regions include agriculture, industry, commerce, tourism, town planning, and social welfare. There is also a list of matters of shared competencies, it's very important, in which the state indicates the principles and the region the detailed rules. On the basis of the principle of subsidiarity, administrative functions are primarily assigned to the municipalities, which play an important role in the decentralized Italian state. The financial autonomy of the regions has been increased, but only on paper. But it will be necessary to wait for the concrete results of the legislative implementation, which goes under the name of fiscal federalism. A procedure has been provided for enabling ordinary regions which so wish and have the financial means to acquire additional powers in matter of shared competence, thus opening the way to asymmetric regionalism. In the years following 2001, the resistance of the central state to accepting the reform emerged. Parliament has continued to legislate on matters of regional competence, in many cases with the approval of the Constitutional Court, which has introduced numerous mechanisms to justify the unifying role of the central state as guarantor of the principle of unity. The Court has sought to limit the power of the central state by applying the principle of loyal cooperation. When the state intervenes in regional competencies, it must do so by ensuring that the regions are involved in the decision-making process. The involvement can range from weak forms, such as consultations, to stronger forms, such as agreements. The main forum for this negotiation between the state and the region is the State-Regions Conference, or when municipalities and provinces are also involved, the Unified State-Region Local Autonomy Conference. These bodies bring together representatives of the national, regional, and local government, but their impact is limited as they cannot intervene significantly in the legislative process due to their lack of constitutional status. So, I mean, in Italy, one of the problem of the Italian form of regionalism, of regional state, of federalism, is the lack of the second chamber of the, that represents the interests of the region. This is very important also in regarding the new role of the regions in the European integration process. Thank you very much.